Two different battles played out before the Delhi High Court today, both tied to the NEET student protests, but dealing with different concerns. First, the National Investigation Agency plea. The court flatly refused to entertain the public interest litigation seeking an NIA investigation into the July 20th Sansad Chalo protest. A bench of Chief Justice D.K. Upadhyay and Justice Tejas Karya did not hold back on the legal problem with the request. The Chief Justice asked, "Tell us what is the statutory mechanism for invoking NIA jurisdiction? The National Investigation Agency is not an inquiry agency, it is an investigation agency." He pointed out that under Section 6 of the NIA Act, there first has to be an FIR, and only then does the process of referring it to the centre begin. Advocate Barun Kumar Sinha, representing petitioner Satish Kumar Aggarwal, who in turn is the ex-vice president of the Akhil Bharat Hindu Mahasabha. He alleges that the protest was transformed into a political agitation involving various political leaders. He also argued that the petition relied not on any scheduled offence, but on the gravity of the offence clause under Section 6, subsection 3 of the NIA Act. But the court was not moved. The Chief Justice responded, "You are asking us to form the opinion that this is a fit case for an NIA investigation. That is the job of the central government. Can we substitute our satisfaction with the satisfaction of the central government?" Sinha then pointed to vandalism of public and private property and asking the court to at least call for a police status report. The court dismissed that too, however. Where is the question of filing status report? FIRs have been lodged 2 to 3 days ago. As you say, these incidents are within notice and knowledge of authorities. Law is in place and they will invoke it. This was the court. When Sinha raised the possibility of a CBI probe instead, the court clarified that the CBI transfers depend on how the primary investigation actually progresses. And that stage, the court said, has not come yet. And now on to the second legal battle. And this one is about surveillance. Former JNU Student Union President AISHE GHOSH has filed a public interest litigation alleging continuous police surveillance, including facial recognition technology, against protesters at Jantar Mantar. Senior advocate Nandita Rao, representing GHOSH, leaned on the Puttaswamy privacy judgment, arguing that even protesters in public spaces retain a right to privacy, subject to a threefold test of legality, legitimate purpose, and proportionality. She cited a specific concern about vans reportedly running live facial recognition, which can possibly mean that an 80% match could keep someone under trial for years. Solicitor General Tushar Mehta countered that videography is a routine law and order tool used at every protest, not just this one, and argued, when you are doing something in public place, claim of privacy is ironical, especially since protesters and influencers were themselves filming interviews and posting online. Rao argued, telling the court, "I urge your lordships not just as parents of Constitution but also parents. Private conversations are recorded. Tomorrow these recordings will be cut, pasted, and I will have to face criminal trial." She urged the court to mandate a clear protocol for the videography and the protesters. With both sides unable to reach common ground, the court said that the matter will now be heard again on Monday, July 27th. LiveLaw has been covering cases related to student protests as they unfold, so keep following us here to stay updated with everything that is law.